from Martineau. I'm very grateful to have them both again with us. It's always a great session. Of course, we'll spend most of the session in information mode, but then obviously there is the ability to ask questions in the chat, which we'll keep an eye on those questions for you as well. All right, so welcome and thank you for joining. If you haven't already, obviously you can join us on the links below, the LinkedIn group, of course, and following us on Twitter, and of course the URL cipd.co.uk/Coventry. Always great to have interaction from our CIPD members on those. Of course, to make things run that little bit more smoothly, obviously while we're running the webinar, if you could please have your microphones on mute to minimize any background noise. As I've said already, you can use the chat box to introduce, say hello, but also ask any questions. And then a couple of reminders: the session is recorded, and we will be circulating the slides and the recording via email after the event. We'll also send you a Survey Monkey request link. If you could please send that out, that'd be very much appreciated. And ideally using your full name in the participant list so we can contact you afterwards if needed. The events that we're running, good news, I guess, in some ways, that obviously we love running these sessions online, but we are starting to run some more sessions face to face. The next 4 coming up, we've got the L&D event, Learning for Everybody, that is developing an inclusive mindset, running on the 22nd of March, online session. Autism and neurodiversity as well. We've got a guest speaker there, Charlie Hart, as part of the Neurodiversity Celebration Week. That looking forward to that session on the 23rd. Assignations, that one is face to face at the Stratford Manor Hotel on the 4th of April. And then we've got our HR Hot Topics networking group, and the next meeting again online is Friday the 8th of April. So if you do want to book your places, and they do get booked up super quick, then please do that via the URL. And of course, if you're a new member or an existing member, just a reminder of the member benefits. I know some of our members who've been with us a bit longer. I guess sometimes it's good to always go back and check the website and have another look, because there's always constantly being things added and new resources being added. So yeah, I think that's the end of my quick, very, very speedy session. I'd like to pass over now to Mike and Helen. Over to you guys. Thank you.
Thanks, Sonia. Good morning, everyone. I'm Helen Hughes, a legal director in the employment team in our Stratford office at Shakespeare Martineau. And obviously, as you can see, with me this morning is Mike Hibbs, a partner in our team. We've got, as ever, an awful lot to get through. So I'm really hoping you've all got a strong coffee there with you. And we will try and get through as much as we can. What we should say, we will pick up questions at the end. Normally there's a volume of questions. If we can't get to them all in the session, we will try and provide written answers afterwards. So don't worry if your question doesn't get picked up. Right, so to kick off, let's just take a very quick look at what we're going to cover this morning. Quite refreshing that we're not going to spend the whole session on COVID and furlough, which I think we have done probably over the last couple of years. But if we can flip to the next slide, you'll see that we've got a case law update. We've got legislation and consultations update, and also just things to watch out for in 2022 to have on your radar, as it were, going forward. Right, so it wouldn't be an employment law update without a holiday pay case. So I'm going to let Mike pick that up first of all. Thanks, Mike.
Yeah, that's exactly right. I think that after the Bear Scotland case, we all hoped that holiday pay cases would disappear, and then a sequence of few drip cases came through, and then we've got this Smith and Pimlico plumbers. And you may remember this case going through because there was a lot of publicity at the time, but it's now gone to another point, to the Court of Appeal, so a further judgment about holiday pay. And Mr. Smith, who was found to be a worker, he'd said that he was self-employed, an independent contractor, and he'd been told that that was the case. He made his claim, discovered that he was a worker as a result of his claim, and now is able to claim his holiday pay. And that's holiday pay back to the first engagement he had with them. So now we have a decision effectively takes things right back, if people work that long, to the beginning of when the working time regulations came in. So if you actually have been employed all that length of time and not had any holiday over that period because you were said to be an independent contractor and you're found to be an employee, then, or a worker, then you'd be entitled to claim your holiday pay back. And that's following a case of King and Sash windows that some of you will have noticed in Europe. So this is a further decision on that line. But rather interestingly, there's no need for him to establish a series of deductions, nor is there any need to determine whether or not he tried to apply to take holiday and was refused, or whether he just simply didn't have any holiday that he was able to be to have taken. There's also this question of the gap of 3 months. Bear Scotland said that there had to be, if there was a gap of 3 months, then you couldn't claim your holidays from before that period because of it being a deductions issue. But it appears from the Court of Appeal that now we have none of that issue either. And the Court of Appeal have suggested a form of words that could best reflect European law on this. And they say, where in any leave year an employer fails to recognise a worker's right to paid annual leave and cannot show that it provides a facility for the taking of such leave, the worker should be entitled to carry forward any leave which is taken but unpaid and or not taken into subsequent leave years. So it's absolutely significant that that's the case. And a whole lot of workers will no doubt be bringing their claims one way or another. But of course, it only applies to Euro leave. So we're only talking about those 4 weeks of European leave. We're not talking about the extra 1.6 weeks, which we get under the working time regulations. For that, you still could have a gap of 3 months, and you could use the 2-year backstop that was put in with legislation. With what happened in the Court of Appeal case, you can't use that 2-year gap. So it's a bit different between whether we're talking about the first 4 weeks or we're talking about the 1.6 weeks extended.
Would like to say that that's made things much clearer, Mike, but I suspect in one sense it's more complicated in looking at the Euro leave and the 1.6. Right, so we're not easing you in gently this morning. We're going straight on to look at disability discrimination. And I just wanted to mention the case of Martin and Swansea City and County, where the Employment Appeal Tribunal had to consider whether there was a substantial disadvantage to an employee, a disabled employee, where an absent management policy contained a discretion. So let's look at the facts just to give you a bit more context. So Mrs. Martin started work in 2014, had a number of stress-related absences 3 years later, and a knock health report advised that she'd got a chronic medical condition that was made worse by stress. Now, the respondent actually was pretty good in this situation. They'd got an absence management policy under which, obviously, it said that someone might end up being dismissed if they were incapable of fulfilling their role. No surprise there. But it also gave them a discretion to find an alternative role instead of dismissal. Now, what was clear in this case, and they really had really tried to help the employee, they'd made significant efforts to accommodate and assist her. They'd put her on the redeployment list. They'd given her a temporary position within the Employee Services Department where she got access to help in applying for alternative roles. They extended the redeployment period from 12 to 29 weeks. But effectively what happened was that Mrs. Martin became disengaged in the process. When she was approaching the final absence review meeting, she told them she expected to be dismissed and she didn't want her departure to be delayed. And she was actually dismissed October 2017. Now, she said that policy that the employer had was a provision, criterion or practice, which probably all of us are familiar with those words in discrimination context. And that PCP put her at a substantial disadvantage as the fact of her disability made it more likely that she would suffer absences than a non-disabled person. And therefore, as a result, she was at increased risk of dismissal. Now, the tribunal at first instance found that the policy didn't put her at a substantial disadvantage because that disadvantage was removed by the fact of the discretion to find her an alternative role. Now, the Employment Appeal Tribunal took a different view. They found that, yeah, the application of the absence management policy, even with that discretion to redeploy, still did put her at a disadvantage because she was still logically at a greater risk of absence than people who are not disabled. And so because the discretion to find an alternative role might not be exercised in her favour, then she remained at greater risk of dismissal. So it looked fairly bad for the employer on that particular point, but what the tribunal and the Employment Appeal Tribunal both found, and this really is the key point, that the employer had taken all steps that were reasonable to avoid that disadvantage. They'd applied reasonable adjustments, effectively meaning that the discrimination claim as a whole wasn't upheld. So effectively the findings regarding the PCP that the employer had applied ultimately had no bearing on the outcome of the case. But nonetheless, still an interesting one just to look at how tribunals break down the different component parts of a disability discrimination claim.
So the next claim also next case is also a disability case. If you think back though to your formal education, how many times were you asked to show your reasoning? So you were actually told that that your answer might have been correct, but you needed to show your reasoning. Effectively, that's what the Employment Appeal Tribunal said in the Gray and University of Portsmouth, that the tribunal itself had not set out its reasoning, and so they sent it back to be reviewed. Mr. Gray was employed in the Information Services Department of the University of Portsmouth and dismissed in 2017 following a 2-year sickness absence related to his disability. And he said that they treated him unfavorably by initiating a formal meeting under their absence process, stopping his sick pay and dismissing him. So those are the claims in terms of discrimination. The tribunal rejected the claim. They said the university had a legitimate aim in ensuring the efficient running of the information service. And they considered each of the complaints and held that the actions taken were a proportionate means of achieving the legitimate aim. When the Employment Appeal Tribunal got to look at it, they said that basically the problem with the tribunal's decision was that they stated that it was obvious that continuing to hold his job open was significantly disruptive to the university, but they failed to explain why. So the judgment hadn't included findings about how Mr. Gray's job was being covered, whether his absence was actually causing any disruption, or whether the university incurred any additional cost as a result of this. So it's gone back to the original tribunal to have a look at that. Now, moving to a different kind of case, agency workers' rights. This is quite an interesting one because in this case, the Court of Appeal said that the right of an agency worker to be notified of a vacancy with the hirer doesn't extend to the right to apply or be considered for the post. So you might think, what on earth is the point of being told that there is a post, but you can't apply for it? This was the Royal Mail subsidiary, Angard, a wholly owned subsidiary, that organised the recruitment of staff for the Royal Mail for their operational post grades, which is OPGs as they're called. And in those circumstances, they offered the jobs, first of all, to those who were already employed, but in less secure roles, but directly employed, before they offered them to any agency workers. And essentially what the Court of Appeal is saying is that that's perfectly okay, and that it would be wrong because of the consequences of it, to enable agency workers to always apply, because actually it's a normal practice, particularly in circumstances where there's redundancy, to allow permanent workers or those who are on less secure roles to be able to apply for the roles first before agency workers. So complying with the regulation, all you simply need to do is to notify an agency worker that there are those posts that are available. Now we're going to move away from case law to look at something completely different.
Temporarily, before we then move back into numerous cases on this. So one topic that is really sort of coming onto the agenda is that of menopause, and we'll have seen that more generally with sort of celebrities starting to talk about their own menopausal symptoms and so on. Now, Michael have to put me on a timer here because I can go on for days about this subject, so I will try and contain myself. But historically, employers have been slow to recognise the issues faced by menopausal women and that they may need special considerations at work. It's often been seen as a taboo subject, with many managers lacking awareness of the impact it can have, and consequently women can feel uncomfortable discussing it and are less likely to ask for workplace adjustments that would help them. But the good news is that change is starting to happen. There's been the publication of a number of studies, reports into the impact that the menopause is having on the workplace and the economy. So only in November last year, the Minister for Employment called on employers to strengthen their support of the careers of women who suffer from serious menopause symptoms. And that was published alongside findings from an independent report commissioned by the government in July 2021, which found that almost 1 in 4 women are forced to leave work as a result of menopause symptoms. And I could go on for hours about all sorts of different stats. But with an ageing workforce and the number of women in work post 50, then you can see that it's really becoming something that employers have got to take seriously. It was only, I think it was last week, Sadiq Khan announced that he was introducing paid menopause leave for City Hall workers as part of a new menopause policy, which included a raft of other measures. So you can see it's a trend that's going to carry on. Many menopause support organisations have been calling for better protection from discrimination for menopausal women, as currently any claim for discrimination based on menopause symptoms has got to be kind of shoehorned into one of the existing protected characteristics, so either sex, age, or disability discrimination. Now, presently, the House of Commons Women's and Equality Select Committee is looking at this issue as a whole as part of their inquiry. And one of the issues being discussed is whether the menopause should be made a specific protected characteristic under the Equality Act. Now, despite the lack of sort of specific legal protection, as I said, employees have had to kind of shoehorn their claim into one of the existing protected characteristics. But there have been a number of cases where employees have successfully been able to do that. And I think it's really interesting to see that there's been a rise in the number of cases being brought before the tribunals referencing menopause symptoms. And certainly we're seeing that borne out sort of at our advisory end when we're being asked to advise employers on this topic. So just one more stat and then we'll move on to the cases. Research by the Menopause Experts Group suggested that there were 16 tribunals citing menopause in 2020, up from 6 in 2019 and 5 in 2018. I don't have a figure for 2021, but I suspect it's going to go, it's only going to increase. Only a few weeks ago, it was reported that a woman was awarded £20,000 by London Employment Tribunal following remarks made by her male boss, who shouted she must be in her menopause. Without going into all the background detail, but the tribunal held that the employer had invaded her privacy, broached a highly sensitive topic for her, and acted tactlessly in directly asking her, as an employee having the protected characteristic of sex as a woman, whether she was menopausal. And he'd asked that question even after she'd made it clear she didn't want to have that kind of discussion. And we're satisfied that part of the reason for the company's decision to dismiss her was that she made these allegations of sexism and ageism against the employer. Now let's take a look at some of the other cases. Any of you who've sort of looked into this area before, you might be familiar with the case of Merchant against BT, and this is one of my favourite cases. You'll see why in a second. So Ms. Merchant was dismissed following a final warning for poor performance. Now, she'd previously given her manager a letter from her doctor explaining that she was going through the menopause, which could impact her level of concentration at times. Now, when her manager proceeded to dismiss her, he chose not to carry out any further medical investigations of her symptoms, in breach of BT's own performance management policy. And his explanation for doing so, which I love, was that he considered there was no need to conduct any further medical investigation because his wife and a work colleague had gone through the menopause, so he fully understood it and was aware of what he was doing. Now, unsurprisingly, the tribunal upheld her claims of direct sex discrimination and unfair dismissal, finding the manager would never have adopted this bizarre and irrational approach with other non-female related conditions. He was also wrong to have considered that his wife's experience was relevant evidence. So here to that, really. Now, where claims are based on disability discrimination protection, we're all familiar with the definition of disability and the need for the individual to show that the symptoms are sufficiently severe and long-term to satisfy the definition of disability. Now, in Danaki and Talent Technology Services Limited, there was an argument that the claimant suffered from typical menopausal symptoms. Now, I forget the precise number, but I think the range of possible symptoms is approaching 50. So quite how they categorized it as typical menopausal symptoms, and that she could undertake all relevant activities. And therefore, the impact on her was not substantial. Now, the tribunal disagreed with what the employer was arguing. They said they could see no reason why, in principle, typical menopausal symptoms couldn't have the relevant disabling effect on an individual. So the door is wide open for someone to be able to establish that they suffer for a disability for the purposes of the Equality Act. Now, there's been the first employment appeal decision involving menopause. That's the case of Rooney and Leicester City Council. And they held that the Employment Tribunal was wrong in striking out the claims of disability and sex discrimination at a preliminary hearing. The case was only held at sort of preliminary hearing stage, so it doesn't involve all the facts of the case, but effectively the claimant, Ms. Rooney, was claiming a whole host of things. She'd been poorly treated, constructive unfair dismissal, sex discrimination and disability discrimination, amongst other things. Now, her solicitors had mucked up, basically, in that on the claim form, they hadn't claimed that she was making a protected disclosure. And they also accepted that her menopausal symptoms didn't amount to a disability. She was unaware of this. When she did become aware, obviously she, probably tore a strip off them, I would imagine, but applied to amend her original claim to include disability discrimination. at the preliminary hearing, the tribunal held that she wasn't suffering from a disability. The matters about which she'd given evidence, such as forgetting to lock the house, which I can go on better than that. I actually leave the keys in the front door on occasion, or engage the handbrake on her car, they considered all to be fairly trivial, considering other day-to-day activities that she undertook for her mother and her family. Now, when it went up to the Employment Appeal Tribunal, they decided that the tribunal had got it wrong. She'd given clear evidence about her menopause symptoms and the effect that it was having on her day-to-day activities, both physical and mental. And she'd been suffering with these symptoms for over 12 months. So her appeals were allowed, and it's gone back down to the Employment Tribunal for a decision on the facts. So I think what's clear with this area is it's one to kind of ignore at your peril, really. We held a webinar on this topic last week, and I think Helen has kindly agreed to send out the link to that if any of you are interested in looking at this area in a bit more detail. One of the points that I would quickly mention is that obviously I've used the term woman throughout this, but obviously the menopause can apply to others, such as those who identify as trans, and that's obviously the general term there. The webinar goes into a lot more detail, and obviously you'll find that from other sources as well.
Okay, so that case, the last case that Helen mentioned involved a protected disclosure, and we're now looking briefly at a protected disclosure case, the whistleblowing and unfair dismissal case involving Kong and Gulf International Bank, where the Employment Appeal Tribunal confirmed that it would be a rare occasion where somebody else's decision-making or conclusions about a protected disclosure was used in terms of a dismissal. It's likely to be only the dismissing people's decision that's likely to be taken into account. And in this case, she was the head of financial audit at the bank, and she raised a variety of concerns to the company's head of legal, saying that the legal documents in use were not fit for purpose. She got dismissed in due course because the head of legal suggested that Ms. Kong had inappropriately questioned her professional integrity and legal knowledge, such that she could not see how she could continue to work with Ms. Kong. And the head of legal brought those thoughts to the head of HR and the CEO, and they all agreed, and Ms. Kong's employment was terminated. So she claimed unfair dismissal, unlawful detriment, and automatic unfair dismissal for having made a protected disclosure. And the tribunal decided that the conduct of the head of legal was detrimental treatment because of Ms. Kong's protected disclosure, but that the claim was brought out of time and couldn't succeed. And they found in favor of her unfair dismissal claim. The dismissal was not fair and was not in the band of reasonable responses for an employer acting reasonably in the circumstances. But they dismissed the automatic unfair dismissal claim because they weren't satisfied that those making the decision to dismiss were motivated by the protected disclosures raised by Ms. Kong, and their decision was down to her raising her concerns and her misconduct. And the Employment Appeal Tribunal, rejecting the appeal, said they were satisfied that the tribunal had correctly concluded that Ms. Kong had not been dismissed because of her protected disclosures, and the automatic unfair dismissal claim shouldn't succeed. They were satisfied the decision makers had reached their decision based on how they believed she'd behaved. And that's going to appeal in the Court of to the Court of Appeal as a floating case. We think on the 25th or 26th of May. So there'll be a further decision in that later on. On to trade unions now, I think.
Yeah, thanks, Mike. Interesting that you use the words reasonable several times throughout that, and I think we'll see that demonstrated in this next case, which obviously will be particularly applicable to those of you who may operate in a unionised environment. Effectively, the nub of the case is an employer becoming frustrated with dealing with a union and trying to bypass it effectively to get agreement to its proposal. So if we just look at the backgrounds, this is the case of Coastal UK Limited and Dunkley. And the Supreme Court held that a one-off direct offer to employees concerning pay, which, as I say, had this effect of bypassing collective bargaining that had stalled, was an unlawful inducement and breached Section 145B of the Trade Union and Labour Relations Consolidation Act. Now, we don't see too many cases on this particular provision, but just to give you more of the context, Coastal had a recognition agreement with Unite the Union that had been created back in 2015. It had a framework for collective bargaining, and it gave Unite sole recognition and bargaining rights. Now, the parties accepted that the agreement was binding in honour, but wasn't a legally binding agreement, as is often the case with recognition agreements. Now, during annual collective bargaining negotiations in 2015, the company had made an offer to Unite, a 2% increase in basic pay and a Christmas bonus equating to 2% of basic pay as well, in return for a reduction in overtime rates, sick pay, etc. Now, that offer in a union ballot was rejected resoundingly by 78% of members. But before the dispute resolution procedures that were set out in the recognition agreement were exhausted, the company made direct offers to the employees. They were obviously really keen to get this pushed through. And they told staff that they wouldn't receive the Christmas bonus if they didn't accept by a certain deadline. Now, that did encourage a number of staff to accept those individual offers. And then following that, the company made another offer to those who hadn't yet accepted, this time without the Christmas bonus, but going a bit further and warning that if the offer wasn't accepted, it may then lead to termination of employment. And we'll see that later on in the session, what we call this firing and rehire scenario. But on this occasion, there was no indication whether there would actually be an offer of new employment. So large number of employees brought claims under Section 145B. And initially, the tribunal found in their favour, making a massive award of £421,000. The company appealed, that was turned down by the EAT, but when it got to the Court of Appeal, the company's appeal was allowed, holding that a one-off direct offer to employees concerning pay wasn't an unlawful inducement. Didn't stop there though, it went up to the Supreme Court. They disagreed, they went back to the original decision to say, yes, there had been an unlawful inducement within the meaning of Section 145B. Now, whilst there are some uncertainties from this case, obviously we've not got time to go into every nuance of it, but I think what it does show us is that you do need to stick with and adhere to the collective bargaining framework that you've signed up to or has been imposed on you by the Central Arbitration Committee. Failure to follow a dispute resolution process will no doubt result in this kind of scenario of being on the wrong side of the law as far as Section 145B goes. Now, I think that's half an hour and we haven't mentioned COVID, but I think Mike's about to correct that for us.
Yes, unfortunately, there's now a whole subset of cases involving COVID, so far only at tribunal decision stage, so none at Employment Appeal Tribunal, so they're therefore not binding on other tribunals, but they do give an interesting direction of travel. So the first of these cases, Cubulus and Kent Foods, was about a driver, a delivery driver for Kent Foods, and the question of health and safety and mask wearing in particular. He delivered most of his deliveries to Tate and Lyle, and Tate and Lyle required face masks to be worn at the Thames refinery site, and all visitors were issued with a face mask on arrival. And on the 21st of May 2020, despite being asked by 2 Tate employees, he refused to wear a face mask while he was in the cab of his vehicle. He was told that without one, droplets from his mouth were going to land on people's faces due to his elevated position in his cab. and that Tate's rules required him to wear a face mask until he left the site. He said that the cab was his own area and he wasn't going to wear a face mask because it wasn't a legal requirement. Tate reported the issue and he was banned from the site for deliveries. And he was invited to a disciplinary hearing, found that he breached the requirements to maintain good relations with clients and to cooperate to ensure a safe working environment, and he was summarily dismissed. And the tribunal said he was fairly dismissed because they had a genuine belief that he was guilty of misconduct, having carried out a reasonable investigation into the facts that were not in significant dispute. It had acted reasonably in treating the alleged misconduct as a sufficient reason for dismissal. Whilst another employer might have given a warning, this was still within the range of reasonable responses for a reasonable employer. And they also took into account the fact that he'd been banned from the Tate site, so it would be difficult to reorganize the work to enable him to do anything for them anyway. The Gibson case, which is the next on the list, Gibson and Lothian Leisure, he was a chef who was furloughed when the first national lockdown began. And the employer asked him to come back into work, and he said he wouldn't because he was worried about catching COVID-19 and passing on to his father, who was clinically vulnerable. And he raised concerns about the lack of PPE and a non-secure COVID-19 working environment. He got summarily dismissed, would you believe it, by a text message with no notice or accrued holiday pay. The message said that they were thinking of running the business with a smaller team after lockdown. So he brought a claim, amongst other things, though, for automatic unfair dismissal under Section 101E of the Employment Rights Act, which is the health and safety one, that employees in circumstances of danger that they reasonably believed to be serious and imminent took or proposed to take appropriate steps to protect themselves or other persons from danger. And in those circumstances, they're protected from dismissal and don't need 2 years service. And his actions were said to meet those requirements. Basically, they also said that in the alternative, given the wording that was sent on the text message, there was possibly a redundancy situation, and he would have been unfairly selected for redundancy because he'd taken those steps. So they found it in both directions. And that really demonstrates that it's possible to make a claim for unfair dismissal on these health and safety grounds, which we were all suspecting was the case, but now it's confirmed. Helen's going to deal with the other three cases, I think.
Yeah, thanks, Mike. The next one, Rogers and Leeds Laser Cutting, again, it's on that sort of health and safety ground where, I think a lot of employers thought they were fairly safe to dismiss employees with less than 2 years service, but without realising that, employees would try and use things in this way, particularly when thinking about COVID. So what happened in this case, Mr. Rogers messaged his manager very early on, 6 days after the first national lockdown, to say he was going to stay away from the workplace. He'd got vulnerable children, a baby and a child with sickle cell anemia, and he didn't want to put them at any risk. Now, a month later, he was dismissed. He didn't have the 2 years service. So as we said, he brought a claim for automatically unfair dismissal on these health and safety grounds. Now, the tribunal held here, having a reasonable belief in serious and imminent workplace danger has to be judged on what was known when the acts took place. So it's no use us now looking backwards, but at that particular time. And on the facts at the particular time, that reasonable belief couldn't be established, so his claim failed. What was really relevant here was that despite his concerns about COVID, he had breached self-isolation guidance. He'd driven a friend to hospital on 30th of March 2020, the day after leaving work. And when he'd messaged his boss, he hadn't actually mentioned concerns about workplace danger, and he couldn't show that there had been any such danger. His employer had implemented all the government safety guidance at the time around hand washing and social distancing. And the tribunal felt that the employer had therefore implemented those safety measures properly, and therefore just because there is the mere existence of the virus, that wasn't enough for Mr. Rogers to satisfy the hurdle that there were circumstances of serious and imminent danger. Now, I think some of these cases, it might be easy to dismiss them on the basis of, well, you know, they're kind of relating to lockdowns, etc. But I think we're seeing a number of issues with employers trying to get employees back to the workplace. And a number of employees still have concerns around coming in as opposed to working from home. So some of these cases will have applicability there too. Similar issues in the Akatatis and Fortuna case. Now, very relevant here that Fortuna was selling and distributing PPE. Mr. Akatatis, so that's a mouthful, isn't it, said that he wanted to work from home due to the risks of the pandemic. But they said, well, unfortunately, you can't actually do your job from home, and furlough wasn't an option. And that was something he was asking for as well, because they were so busy. So to try and be reasonable, the employer said, well, look, either take paid annual leave or unpaid leave. But he wasn't happy to do that. He kept repeating that he wanted to be placed on furlough. Eventually, he was dismissed for refusing to come into work. And again, he raised an automatic unfair dismissal claim. Now, the tribunal agreed with Fortuna that they'd reasonably concluded that his job couldn't be done from home and that he didn't qualify for furlough, and that they'd been reasonable in suggesting that he could take the other time off. His response was that he obviously wanted to stay at home or be placed on furlough on 80% of pay, and they were not appropriate steps to protect himself from danger. So his claim failed. So again, it's just this line coming out from the tribunals that an employee simply can't refuse to attend work due to concerns over COVID-19, particularly if their employer has addressed those concerns and undertaken the appropriate risk assessments. Now, quickly moving on to the case of Carton, I think it's gone in primarily because it involves solicitors getting it wrong, which people always like. But effectively, at the start of the first lockdown, this solicitor's firm furloughed half of their staff, with the remaining staff expected to take on their work. The remaining staff were also required to agree to a change in their employment contract that could require them to go on furlough immediately or have their hours and pay reduced on 5 days' notice. Now, Ms. Cartoon refused. She was told that those variations were non-negotiable. If she didn't agree, she would face immediate dismissal. She was given 24 hours to sign it. She refused, and after a limited back and forth of emails, the head of department had a 5-minute call with her, in which he stressed again the changes need to be agreed to. The following day, she was dismissed because her position didn't alter. Now, unsurprisingly, it was held her dismissal was unfair. They agreed with the employer that whilst their reasons were sound, there were sound business reasons for wanting to make the change, the way they'd gone about it was unreasonable. There was no adequate consultation. It was all a one-sided conversation, and everything was done far too hastily, with Ms. Cartoon not being even offered an appeal, and they found that a reasonable employer would have done more. Now, the relevance of that case obviously is a number of employees have had to try and change terms and conditions during the pandemic and may still have need to do so. So it just emphasises the importance of engaging in a thorough and reasonable process to do that. Now, the final COVID-related case that I want to talk about actually involves COVID vaccinations. We're all aware, probably November 2021, the government introduced a new law requiring mandatory vaccination for staff in CQC registered care homes, and then the same requirements were due to be rolled out for all NHS staff on the 3rd of February. Again, we're probably all aware that the government has done a U-turn on its plans, citing that it's no longer proportionate to require vaccination as a condition of deployment by statute. Now, this case, Alette and Scarsdale Grange Nursing Home, actually involved a care worker who was dismissed for refusing to agree to a vaccination, when at the time there were no laws in place requiring mandatory vaccination. But interestingly, it was held that she was fairly dismissed. At the time, obviously, COVID was far more prevalent and the risk to individuals far higher, because we were looking at December 20 and January 2021. This particular care home decided in December 20, when the rollout of the vaccines were just starting, that they wanted to make it a condition of continued employment that all staff be vaccinated. She refused, arguing she didn't believe in the vaccine safety. Ultimately, she was dismissed following disciplinary process, and her claims for unfair dismissal fell for various reasons, including the fact that the mandatory vaccination policy introduced by the employer did meet a pressing social need of reducing the risk to residents. It was accepted she had a genuine fear of the vaccine, but it was unfounded and unreasonable. And the care home had a duty, both moral and legal, to protect its residents. So in one sense, this particular case, less applicability now that the compulsory vaccination is no longer law. And one does have to wonder whether, set against the current landscape, whether the tribunal would have made a different decision. But I think what it does show is that it's been a movable feast, hasn't it, over the last 2 years. The constant changes in these COVID times shows just how important it is to always seek advice on your particular business circumstances before introducing any COVID policies or taking any related disciplinary action. Okay, back to you, Mike.
Yeah, so we're now looking at legislation and consultations, and particularly starting with flexible working consultation. And many of you may be feeling that this is old hat now as a result of 2 years of changes in lots of workplaces. So flexible working has been a reality for a lot of people, and the legislation looks very inflexible. But the government started some consultation, which ended in October 2019, and then they started again another response published on the 23rd of September 2021, because the questions are whether or not flexible working should be a day one right, and indeed whether it ought to be automatically granted unless the employer can prove a reason otherwise. At the moment, of course, you've only got the right to request, and that can be turned down on one of the 8 business reasons. And the government is looking at whether or not those ought to be changed as well. Now, that consultation all closed on the 1st of December last year, and it's pretty clear that there's unlikely to be a response in this first half of this year at least, and it may well be into the next half. And for many employees that won't be important, but for lots of employees it will still be very significant when they see other workers being able to work from home, work variable hours, all sorts of things, and they don't seem to be able to get that opportunity. Helen.
Thanks, Mike. I've mentioned a couple of times so far this issue of firing and rehiring. It had a lot of prominence earlier on in the pandemic, when lots of big organisations were having to implement this. Just wanted to say that the government has confirmed it won't legislate yet to prevent these kind of firing and rehiring practices. Instead, what they'd asked ACAS to do was prepare more detailed guidance on how and when dismissal and re-engagement, that's what I mean when talking about firing and rehiring, when that should be used. Now, 11th of November last year, ACAS published that updated guidance, advising that fire and rehire is a really extreme step that can damage staff morale, trust, productivity, and working relations. And obviously trying to negotiate changes by consent is always the preferable way following full consultation, so that employees can try and understand the reasons behind the proposed changes and give their views, which is more likely to lead to agreement rather than having to go down this route. Now, really quickly on this point, I did just want to mention the Asda and Tesco stores case, where the High Court recently granted an injunction restraining the supermarket from withdrawing a contractual benefit by means of termination and re-engagement. Very unusually, the union went to the High Court for a declaration to confirm that their contracts were subject to an implied term preventing Tesco from exercising its contractual right to terminate for the purposes of removing the employee's right to something called retained pay, which was a very specific benefit that had been given to these particular employees. They also sought an injunction stopping Tesco from terminating the affected contracts, and that was granted. Now, that's it's not an unheard of way of trying to enforce rights, but it's quite an unusual one. And I think what it demonstrates, in very particular circumstances, which these were, courts will take the necessary steps to protect employees' rights in that way. Okay, Mike.
So ethnicity pay gap reporting has been on the agenda for quite a while now. At the end of 2019, the government launched a consultation on that, which closed in January 2020, but the government has still failed to publish its conclusions about that. Then there was a parliamentary petition with over 100,000 signatures calling for them to introduce mandatory ethnicity pay gap reporting. The government instead set up a new cross-government commission on race and ethnic disparities to include that. And the debate on the 100,000 signatures was on the 21st of September 2021, and the government said they would respond in due course, which is their favourite expression at the moment. Everything's in due course. What's happened on the wider basis is that the NHS in 2018 actually became the first public sector organisation to publish breakdowns of pay for all staff by ethnic groups. And you at the CIPD published the Ethnicity Pay Gap Reporting, a guide for UK employers, on the 15th of September last year, with recommendations of how to approach those difficult questions of what groups of people you report on and which categories you use and so on. The latest is that HR Data Hub has reported that half of the companies that reported their ethnicity pay gap in 2020 then reported in 2021. So only half. It's going down rather than up. The only good news is that there is news of the Parker Review reporting to say that at least one person of ethnic minority is on the board of every FTSE 100 company, which was a target they were seeking to meet by the end of last year, and they've done that. That doesn't mean to say there aren't further targets to follow. The gender pay gap reporting regulations need to be reviewed by April. That's part of the conditions of those by the government, and they'll be looking at how effective those have been. What is interesting is the TUC have done some analysis on this, and they say that women work an average of 56 days each year for free due to the gender pay gap, which currently stands at 15.4% on all employees. And the gender pay gap has fallen by an average of 0.6% a year since 2011. So it will take until 2049 for pay parity between men and women. The gap persists particularly in industries dominated by women and is larger than average in education at 26% and social care 18%. And the highest gap, 32.3%, is in finance and insurance, where women work the equivalent of 118 days for free. Age has a big impact. Those between 40 and 49 and 50 and 59 have a larger pay gap than average of 21.3% and 21.8% respectively. There is also now a suggestion of disability workforce reporting for employers with 250 or more employees. And so the government are thinking about consulting on that, and the consultation, in fact, is out, and submissions can be made until the 25th of this month. So you need to get a move on if you're going to respond to that particular consultation. Carers leave is going to be introduced if you haven't picked that up, but it's going to be when parliamentary time allows. It will be a day one right, and the person being cared for will include a spouse, civil partner, child, partner, or a person living in the same household as the employee, other than by reason of them being their employee, tenant, lodger, or boarder, or a person who reasonably relies on the employee for care. And the person being treated must have a long-term care need. But the right is only to 1 week, 5 working days of unpaid leave per year, taken in a single block or more flexibly on individual days. The coronavirus right to work checks, which, as you know, can be done over video calls, and those are being continued until the end of September now, the 30th of September 2022. And so from October, you go back to seeing the original documents. And the other thing to mention is the closure of the statutory sick pay rebate scheme. And that's today. It closes today. So that situation where employers could claim back statutory sick pay for their employees' coronavirus-related absences or self-isolation will end today. That's the last time you'll be able to do it, and it goes back to normal SSP rules after that.
Okay, thanks, Mike. Really quickly, statutory rate increases, doing an update at this time of the year, then we always need to just update you on those. They'll apply from April 2022. SSP will go up to £99.35 per week. SMP, paternity pay, etc., the weekly rate will go up to £156.66. National minimum wage, I won't go through all the different age brackets, but again, the hourly rates to apply from 1st of April. So for those over 23, we'll be looking at £9.50. As I say, I'm not going to go through all the others, but we can send that information out if anyone needs it. The compensation limit, so a week's pay for the purposes of a basic award for unfair dismissal or a redundancy payment, that's going up from £544 to £571. And the maximum compensatory award for unfair dismissal claims, that's increased from just under £90,000. That will now be £93,878 in respect of dismissals occurring on or after the 6th of April. So if we just flick to the next slide, we'll see the other things to keep an eye out for in 2022. So consultation on sexual harassment in the workplace. Now, the original consultation ran from July to October in 2019, and like a number of the consultations we've looked at during this session was obviously put on hold in view of the pandemic. But as a result of that, it was found that many were supportive of a new duty to prevent harassment, including explicit protections from third-party harassment. And the government does intend to introduce a duty on employers to prevent sexual harassment and to encourage employers to take positive, proactive steps to make the workplace safer for everyone. A lot of that was driven by the Me Too movement in the first instance. They also are going to look at extending the time limits for bringing Equality Act discrimination-based cases. Obviously, at the moment, it's 3 months. They're looking at increasing that to 6 months. And moving on to neonatal leave and pay, it was announced just before the first lockdown when the government responded to a consultation on neonatal care, that they proposed the introduction of statutory neonatal leave and pay for up to 12 weeks for parents of babies requiring neonatal care. And the government have said they will legislate to introduce that in the forthcoming employment bill.
Next, confidentiality and non-disclosure agreements. Way back in July 2019, the government published its proposals to prevent the misuse of confidentiality clauses. They said that there is some value to having those, including non-disclosure ones, but they were being used in the wrong way. And legislation is going to be brought when parliamentary time allows. You're getting used to this expression, it comes up all the time, but we'll see whether it gets put into the long anticipated employment bill, or there's a separate piece of legislation to curb those uses. Redundancy protection for women and new parents. The plan is to extend that. So this is from 2021 in June. There's a private members bill going through Parliament at the moment called the Pregnancy and Maternity Redundancy Protection Bill. But whether that will succeed or whether we'll wait to the government putting their own bill through as part of the employment bill. The idea being that redundancy will be prohibited during pregnancy and maternity leave and for the 6 months after the end of pregnancy or maternity leave, except in certain limited specific circumstances. Finally, in terms of things to look out for, particularly the Harper Trust and Brazil case, which was heard by the Court of Appeal, sorry, the Supreme Court rather, on the 9th of November last year. And that affects part-year workers, those working only part of the year, such as during school terms, should have their annual leave entitlement capped at 12.0% of 07% of annualized hours. The Court of Appeal gave Unison permission to intervene in the latter stages, and it will be interesting to see how that affects part-time employees generally. We've got some credible anecdotal evidence that suggests that the judgment is going to be handed down before the 19th of May. So sometime in April is what we're expecting, but do keep an eye out for that. So those are the things we wanted to talk about. There was one question that was sent in before today by somebody, and I thought I'd quickly answer that one, which was about the percentage success rates in unfair dismissal and disability claims. There aren't any reliable statistics that can give you that particular answer, but in looking at that, I looked at the statistics generally, and it is quite interesting that 14% only of cases get to a full hearing, so of cases that are launched in tribunal, and 53% of cases are withdrawn, usually because of settlement. It's the case that roughly 50% of claimants win and roughly 50% of respondents win, which tends to suggest that the tribunals overall get things about right. Unfair dismissal cases, the average award is £10,800, and disability discrimination cases, the average award is £27,000. So hopefully that's helpful to whoever asked that question beforehand.
Okay, thanks, Mike. I think we can see on the chat function that there are some questions, so we'll try and pick up a few of those in the time that we've got left. I think we've got about 10 minutes. So I'll pick up the first one that I can see, which effectively is a COVID question, and surprisingly, an employee is classed as extremely vulnerable. Government advises they can return to work. The individual doesn't want to come back to the office. There's a medical advice, a consultant letter recommending working from home due to risks. What can we do to get them back into the office? We've offered them the right to request flexible working. Is there anything else we can do? I mean, obviously, what we've got to be mindful of here, if they are classed as clinically vulnerable, they would probably satisfy the definition of disability under the Equality Act. So that will trigger the obligation to make reasonable adjustments. The fact that you've got medical evidence recommending working from home is also highly relevant here. I think you would have to be very careful about forcing them to come back into the office, and I don't think that's what you're suggesting at all. I think you have to look at what they have been doing over the last 2 years. Have they actually been able to work adequately from home? What is the reason now for wanting them to come back into the office? Is that just as a number of employers are thinking it's the benefits of having people back in, the collaboration, the increased productivity, etc. I don't think there's any easy answer to this, other than it's perhaps an ongoing process in terms of the employee feeling reassured enough that they are able to come back in due course as the risk from COVID decreases. Whether it's worth, obviously I'm unclear whether the consultant was fully appraised of all the facts and all the safety measures that you may have in place, in terms of ventilation, cleaning, distancing, etc. Obviously, a number of employers are still continuing with those kind of measures to make the workplace as safe as possible. So whether, if that hadn't been clear to the consultant, whether it's worth trying to get an updated report. Other than that, I think it's an ongoing consultation with the individual around encouraging them back when they feel able to do so. It would obviously be a different answer if they are unable to work from home, because then you're into different territory of whether they can actually do their job from a capability perspective.
I'm conscious of time, but I'll answer the next one, and then obviously any that we haven't answered, then we'll answer later in due course anyway. So thank you for those who are staying on. I know we've run over time a little. So the question is, where would we stand if somebody wants to come to work if tested positive for COVID but shows no symptoms? With the recent change in law not legally having to self-isolate, are we able to ask them to keep isolating as per the previous rules? Yes, you are able to do that on health and safety grounds if you reasonably believe that there is a risk to others, and quite self-evidently there is. The fact that somebody is not showing any symptoms does not mean that they're not infectious to other people, and that other people won't suffer symptoms if they are infected by this particular individual. So yes, you can cause them not to come into work. It begs the question, though. You say that they've tested positive for COVID. Many people are not bothering to test anymore, so the chances of spotting people and knowing about this are getting less. But nonetheless, for health and safety reasons, absolutely you can. Back to you, Eleanor. Are you taking it next?
Yeah, so Sonia's had to dash off because she's got off on a meeting to go to. So let us say on behalf of the branch, actually I'll stop sharing the screen as well so I can see everybody. Yeah, on behalf of Coventry and Warwickshire branch, thank you to everybody for joining us today. I hope you found it a useful session. Thank you very much to Helen and Mike. Again, another excellent employment law update. Very sorry for the technical hitches at the beginning. The session has been recorded, so if you missed anything, I'll send the recording out later this morning, so you'll be able to pick up anything that you missed from the recording. So once again, big thank you to Helen, Mike, and we'll see you all on the next session. Thank you.
Thank you.
Thanks very much.